Great. Good afternoon, everyone. Hello, my name is Susan Brooks, and I am from RCM of Washington.
And I'm Allison White, and I am the Executive Director of the DC Developmental Disabilities Council. And it is our honor to welcome you to the third and final session of the Bridging Aging and Disability Network's Future Planning Lunch and Learn series. The purpose of our DC's Bridging Aging and Disability Networks and Racial Equity Community of Practice is to, one, better support individuals with IDD, intellectual and developmental disabilities, as they age while maintaining dignity and rights. Two, to better support and connect with aging caregivers, which includes family caregivers, but also paid caregivers like direct support professionals or home health aides. Three, build capacity for racial equity across aging and disability networks in DC, which includes a lot of work with the Department on Disability Services and the Department of Aging and Community Living, which I'm sure many of you are familiar with. And four, to build sustainable relationships between the aging and disability services networks.
And at today's event, we are excited to be offering interpretation into Spanish, American Sign Language, Mandarin, and Amharic. If you need interpretation, please click on the icon and choose the language channel you need. We ask that today everyone please use the chat for any questions, and those questions will be monitored. We also want to remind people that this session is meant to provide an overview of information and resources. We can answer generalized questions, but we are not going to be able to answer person-specific situations. Instead, we hope that these resources and information provided here today will help connect you with organizations that can help you in the future.
So I want to thank you again all for being here for our third and final session. All of these sessions are recorded and will be posted on our website in the near future. And we'll put that website in the chat a few times throughout the session so you won't lose it. Our first session as a review was an overview of future planning and disability and aging services in the district. Our second session focused on financial options for future planning, like accessing public benefits and how to save money for the future. Today's session is about decision-making options. We'll discuss some hard but important questions about how we plan for ourselves and our loved ones if or when we lose the ability to make decisions. This is an issue we have faced in my own family. I'm the younger sibling of a person with a developmental disability who recently moved in with me after living in a group home setting for 20 years. I am also the child of two parents who are aging and beginning to need more support. I want to support all of them in making their own decisions about the things most important to them for as long as possible. I also want to plan for what to do if any of them become unable to make decisions independently. And of course, I worry about how they will get support if something happens to me. Today's session will present all the options available for families like mine and yours too.
Thank you, Allison, for sharing a little bit about your personal story with the group. So next, we would like to introduce our co-presenters for today, Sean Allman, CEO of Quality Trust for Individuals with Disabilities, and Sandy Bernstein, Legal Director of Disability Rights DC, who will be sharing a presentation on decision-making options for people with intellectual and developmental disabilities. Welcome, Sean and Sandy.
Thanks for having us.
Thanks, Susan. Sandy, I'm going to let you go and introduce yourself first. And Susan, if you could just share the presentation when you have a minute.
No problem. I believe Allison is sharing today. There we go.
Great, great. Well, good afternoon, everyone. I am Sandy Bernstein. As Susan said, I am the legal director at Disability Rights DC at University Legal Services. We are what's called a protection and advocacy program for people with disabilities. And we are the protection advocacy program for DC. There's one in every state that advocates on behalf of the civil rights, the service rights, of people with disabilities, with a focus on making sure that people with disabilities have the rights that everybody else have and are able to live in the community along with their friends and family and neighbors. So thank you. I'm very happy to be here today, and I'll let Sean introduce herself.
Thanks, Sandy. Hi, everyone. I'm Sean Ullman. I am the CEO of Quality Trust for Individuals with Disabilities. We are an advocacy organization in DC, and through monitoring, advocacy, and our legal team, we look at the services and supports people receive. We make sure they're getting what they need, and we help advocate for their wishes expressed and the wishes that they express, and make sure that they're getting the services and supports they need, and that their rights to make their own decisions are respected as much as possible. You can go to the next slide. So today we're going to cover what guardianship is, why you should consider alternatives, what the alternatives to guardianship are, and planning for changes in decision-making in the future. You can go to the next slide. So many of you may know, especially if you're dealing with aging issues, that parents do not automatically become the legal guardians of their children, even when they're children with disability, even when their children have disabilities, when their children turn 18. Guardianship is a formal legal process where the court determines whether the adult is incapacitated, which means that they're unable to make some or all of their own decisions. If the court makes that determination, then it decides whether someone else, which is called a guardian, will be court appointed to make some or all of the person's decisions for them. Guardianship doesn't just mean going to court. It also means getting a court order and subjecting both the person under guardianship and the guardian to regular court oversight. You can go to the next slide. There's a lot of information on this slide because the guardianship process in DC and elsewhere is not quick and easy. The guardianship processes do vary by state, but in the District of Columbia, petitions are filed in what's called the DC Superior Court Probate Branch. The first thing the judge will do is appoint an attorney for the person who has a disability. The court may also decide to appoint other people to be involved in the proceeding, and we've listed some of them here on the slide. One of those people is what's called a guardian ad litem, or GAL. The GAL's job is to help the person with the disability determine what their own interests are. And if the person isn't able to communicate those interests, then the GAL will determine what is in the person's best interest. The judge may also appoint a person called a visitor. That is just a special name for the person who is usually a social worker. And they investigate who the proposed guardian will be, what the living circumstances will be, and then they'll make a recommendation to the court about what they think is appropriate. The judge may also appoint someone called an examiner, and that's usually a clinical social worker or a psychologist who will do a formal assessment of the person's capacity and ability to make their own decisions. What the judge won't usually do, and this is often a surprise to people who are filing for guardianship, is appoint an attorney for the person who wants to become the guardian. If that person wants an attorney, they have to find their own attorney. So after deciding who all is going to be involved in the guardianship hearing, the court will next hold at least one court hearing where they'll hear evidence about the supports that the person does and doesn't need. And then the judge will make a decision. The first question that the judge will decide is whether or not the person is incapacitated. And if so, in what way? So someone doesn't necessarily, the judge won't necessarily find that a person is incapacitated with absolutely everything they need to decide. They might find that they need help on some things, or they need someone else to make decision for some things, but the person can still make their own decisions for other things. After that, the judge decides whether or not a guardian is necessary. And this is when the court should be looking at whether there are other interventions other than guardianship that could help the person. If the judge thinks the person is indeed incapacitated and that a guardianship is needed, then the judge will decide what the guardianship covers and who the guardian will be. So it's important to think about less restrictive options before going to guardianship, because the court's going to look at that anyway. And there are so many important reasons for why we should do this, and certainly why a court should do it. One is that guardianship takes away some or all of a person's right to make important decisions about their life, things that we all care a lot about for ourselves and usually don't want someone else making decisions for us. The court also becomes a part of both the guardian's and the person's lives going forward. It isn't simply getting a piece of paper. Guardians have a lot of legal responsibilities, and it invites courts into the lives of the person, their family members, their other caregivers, as long as that person is under guardianship. Guardianship typically lasts until the person under guardianship dies, or until the court finds that the person can make their own decisions and restores their rights. In DC, guardians have to submit to a criminal background history, fingerprint, and they have to submit, if they're chosen to be guardian, they have to submit reports to the court every 6 months. There may also be additional hearings, and guardianships are usually reviewed by a social worker every 3 years to make sure they're still needed and that everything is still going well. Guardianships can change the relationships between the person with the disability and the person chosen to be their guardian. We often get calls from adults who are really unhappy with their guardians, even when their guardians are their parents. It's because they feel disempowered and feel sometimes like they're being prevented from growing up and becoming adults. So those are important things to think about when you're considering whether to pursue a guardianship or another alternative. A few other reasons are that guardianships can take time and cost some money, especially if the person who wants to become guardian has to find their own attorney. And if you want to change the guardianship in the future, they can be hard to modify or terminate. One thing that Quality Trust and Disability Rights DC both want to remind people of is that making decisions is something that we all learn to do. You need to have the opportunity to practice, and with practice and time, most of us over the course of our life get better at making better decisions and becoming more independent. And guardianship can get in the way of people practicing those skills and helping them grow and become more independent. Next slide. A few other reasons are that having self-determination, controlling your own life, and making your own choices leads to better life outcomes. People are healthier, both psychologically and physically, and there are decades of studies that show this, including research that demonstrates that young people with disabilities who are supported to exercise self-determination or being in control of their own decisions, being the actor, if you will, of their own choices, they're able to make a more smooth transition from education and childhood to adulthood. They're typically more integrated in the community, and they usually have better employment outcomes. Next slide. One final thing I'll say on why to choose alternative is that it's really important that we rethink how we talk about capacity. Capacity isn't an all or nothing determination, and it shouldn't be based solely on someone's IQ or their diagnosis. Many people have the capacity to make some decisions, but not others. They may be able to make decisions at some times, but not at all times. And they may be able to make decisions if they get help understanding what their options are. And as we talked about on the previous slide and here, having a lack of opportunity to practice making their own decision results in that ability decreasing over time. So it's important that capacity be grown through time and practice. Next slide.
I'm going to take over now. And so you heard Sean talk about the issues that can result from guardianship. And while it may be needed in some limited circumstances, we're lucky that there are lots of alternatives that can provide support to people who need decision-making support. And I've listed a couple here. This isn't an exhaustive list. This isn't all of them, but these are the ones we're going to discuss today, and really the main ones that exist in DC. We're going to talk about supported decision-making agreements, powers of attorney, healthcare directives, joint bank accounts, direct deposit, automatic billing, financial ways of sharing decision-making, educational representatives, representative payees, and substitute healthcare decision makers. Next slide, please. So we're going to start with supported decision-making. Several years ago, just a few years ago, supported decision-making became a law in DC, meaning it was something that had to be recognized as an option and an alternative to guardianship. And so right here we have is the legal definition, which is why we have the site here for the DC code underneath it. And what supported decision-making means under DC law is a process of supporting and accommodating an adult with a disability to assist that person with a disability in understanding the options, responsibilities, the consequences of any decisions they make, but really enabling the person with a disability to make life decisions themselves without taking away their own decision-making rights, without taking away their self-determination, or making decisions on their behalf. You're allowing them to keep that right to make their own decisions. Next slide. So what does that mean? That was the legal definition. What does that mean? It really supported decision-making really starts with the idea that people with disabilities can make their own decisions, and they may just need support from the people that they want and value in their lives. Supporters can be whoever the person with a disability wants. For some people, that may be their family. For others, it may be their friends, their neighbors, professionals, other people that they know. The idea is that you're a person with a disability and you're reaching out to someone that you trust to help you and support you in understanding the choices of different decisions, asking questions when you need to make a decision, receiving explanations in languages that you understand, and helping you communicate your decisions to others. It really is what we all do every day, right? None of us, having a disability or not, make decisions completely in a vacuum alone. I don't know much about cars. So when I'm thinking about buying a new car, I may ask my brother-in-law, who's really savvy about cars and knows the best ones with the best mileage, but I make my own decision. I just reach out to a supporter to help me. And so I can ask questions and it can be explained to me in a way that I understand. Supported decision-making really has the same values that people with disabilities want to be able to make their own decisions. They just may need support to do so. Next slide, please. So like the example I gave where I'm going to my brother-in-law, that is not, I don't have a supported decision-making agreement with my brother-in-law. That's an informal way for me to get support in decision-making. That is an option for people with disabilities as well. It's also an option to have a formal supported decision-making agreement or a legal document. And that's what the law changed back in 2018 in DC, saying that the court had to recognize, the city has to recognize supported decision-making agreements, which is a way to put in an agreement that is legally enforceable, saying, I want this person to help support me in making decisions, whatever those decisions are and whoever that person is. It may not be the same person for all decisions. It may be that I want a supporter to help me with housing issues who's my sister, and I may want my neighbor to help me with banking decisions. It doesn't have to be the same person. But DC recognizes two different supported decision-making legal agreements that people can enter into, people with disabilities. The first one is, as we have listed here, is one with OSSE, which is the Office of the State Superintendent of Education in DC, or the DC Public Schools. It's their supported decision-making form. And we've included the link here. If you have the PowerPoint, you'll be able to click on that and be able to get the form. And what that really allows for is for people who are over 18, who are still in special education, who want assistance and want support in making educational decisions. They can appoint, or they can say, this is the person that I want to support me in making educational decisions. The second one, that is only for educational decisions. The second one is, again, for adults with disabilities, for people who want any other type of life decision, any type. It can be housing, financial, health, someone who wants to be able to make their own decisions, but wants to name somebody as a supporter to help them. And as you see, there's a link here. And if you look at these forms and you think they're confusing, you can certainly reach out to Disability Rights DC, my organization, or to the Quality Trust if you have any questions and don't know how to complete them, or also to find out any information about who can be a supporter. Because while the person has the right to choose who would be a supporter, the law does create, oh, we lost the PowerPoint. The law does create some restrictions on who can be a supporter. I won't get into that too much here, but to give you an idea, there are certain felonies. If people have committed a certain felony within the last several years, then that person by law is not allowed to be named a supporter in a supported decision-making agreement. So if you have any questions, you have family members who have any questions about how supported decision-making agreements work, please reach out to either my office or to Sean's office. And I think we're ready to move to the slide that says power of attorney. Yay. Okay. So a lot of you may have heard of a power of attorney. This is something, it's a legal document that a lot of people with disabilities and people without disabilities have. It's a legal agreement that allows somebody to assign decision-making to somebody else in whatever area that person wants. And the great thing about a POA is it doesn't involve the court. It's a document, usually a lot of people go to a lawyer to have it drawn up. You don't have to, they have forms available. I think even Staples has forms available, but they are forms that you're assigning someone to make decisions on your behalf. And usually you have to have a witness, and in most states in DC you do witness, and you have to have it notarized. And you can make it as narrow or broad as you want. So just say, for example, when I was buying a house many years ago, my husband wasn't available to go to the closing when we closed on our house. And so we actually drafted a power of attorney that I could only make that decision for him. I could sign his name, basically, I could sign my name as his agent to close. And that's it. After that day ended, I had no more authority to make decisions on his behalf. That's the great thing about a POA is you can make it as narrow or broad as you want. It can be all decisions. It can be some decisions. It could be all decisions for a certain period of time or a longer period of time. It's really up to the person. It allows the person to make decisions about who they want to make decisions for them. Another great thing about the power of attorney is if you change your mind, then you just dissolve it. You just put in writing this, I no longer want my husband to be my power of attorney. And then you have to notify anyone that you sent the power of attorney document to let them know it no longer exists. You don't have to go to court. You don't have to do anything like that. Very, very different than a guardianship. Also, if I give power of attorney to someone else, or someone with a disability gives power of attorney to somebody else, that doesn't mean they no longer have the ability to make their own decisions. So if I say I want my sister to have power of attorney over financial and housing decisions, that means my sister can make decisions on my behalf. It also means that I can still make the decisions. It just adds someone else. It doesn't take away my ability to make decisions. Another great thing about a power of attorney is when you're working with someone with a disability who may not understand a lot of legal terms, right? A lot of us don't. But if you're looking at a power of attorney and the person wouldn't be able to understand all of the legal terms and all of the intricacies of the power of attorney document, they can still sign the power of attorney document as long as they understand that they are giving decision-making power to somebody else in a specific area. That's all they need to be able to understand. So they don't have to understand all the decisions the person is making. If I'm allowing someone to make medical decisions for me from a power of attorney, I don't need to be able to understand all the intricacies of whether or not I want chemotherapy or radiation. I just need to understand that I want my sister to be my power of attorney to make those decisions. And so that's really great also, because, you know, we have people who come to my office who maybe can't understand everything on the document, but they do understand that they want their mom to help them with decisions. And so they are able to sign a power of attorney and have control over the decision-making rather than having a guardian appointed where they don't have control. Even in the best of circumstances, they have given up control of their decision-making. And so next slide. Healthcare directors are a type of power of attorney. You may have heard of them called healthcare powers of attorney, medical proxies. They have lots of different names that people refer to. But what it is a healthcare, an agreement, a power of attorney, where you are allowing somebody to make healthcare decisions on your behalf. So these could be decisions on what medication to take. This could be life-saving techniques, whether or not I want to be on them if something happens to me. If I want you know, so if something happens to me medically and there's procedures or testing or surgery needed, that person would make decisions. And again, the person is deciding if they want to have someone be their power of attorney and who they want that person to be. The important thing about a healthcare power of attorney, which is different than a power of attorney for any other reason, is a healthcare power of attorney does not take effect until the person lacks capacity. So remember how I said for other powers of attorney, I maintain the decision-making authority and I can make housing decisions, or my husband can make housing decisions if he's my power of attorney. For a healthcare power of attorney in DC, it only comes into play if I am unable to make decisions. So if I sign, for example, I do have a healthcare power of attorney, and it says that and that my husband is my healthcare power of attorney. But what that means is he can only make decisions if I am unable to. Either that's because I'm unconscious, something happens to me that I lose capacity, or some other reason that I'm unable to consent. That is the only time that a healthcare power of attorney comes into play, when the person is unable to make healthcare decisions themselves. Okay. We'll move on to the next one, please. Okay. So financial, it's for people who need financial help. We all use people with disabilities, people without disabilities, different ways to help us manage our money and to look for people's help and advice. So we can have joint bank accounts with our family members. We have somebody else managing the money that comes in and making sure that we're not spending too much, or, you know, we're making sure different bills are getting paid. You know, direct deposit, having your check put right in, whether it's benefits or an income, so you know that you don't have to go to the bank, that you're going to have money in every month. You don't have to worry about that. You also can have somebody who's then monitoring if anything strange is happening with your account, and then can help you go to the bank and resolve it, rather than, oh, your name's not on this bank account, so only the person with the disability can go in. Automatic billing. I love this myself. For someone who sometimes misses mail or forgets to pay something on time, happens to all of us, sometimes more than others, but you have automatic billing where you could have your rent, your utility, your student loans, whatever it is, taken automatically on a date you choose out of your account. So that is a way to have basically decision-making help just through technology, which is great. And it's also great to have, especially if people get SSI or Medicaid, to have someone else, if you need so, if you're a person with a disability who needs that extra support to make sure that you don't want to lose your benefits, then if you have someone in a joint bank account involved in your banking, then they can also make sure that you are not over the asset limit. Because as you may or may not know, SSI, you only can have $2,000 in the bank. DC Medicaid, you can have $4,000 in the bank. And if you have more than that, you're in jeopardy of losing your benefits if it's in a regular bank account and not a trust. So it's good to have some extra support if you want that, to make sure that doesn't happen. Okay, next. Okay, so representative payees. This is another type of financial support that exists for people with disabilities for people who receive SSI or SSDI. So this isn't something that you basically sign up yourself. You're appointed by the Social Security Administration when the Social Security Administration, SSA, says, we don't think that Sandy has the capacity to handle her SSI check. And so they appoint what's called a representative payee. And that person is responsible for making sure that I get my SSI check and that it is spent in a way that helps to make sure that I have my housing, make sure that I have food, and whatever else I need. And they have to answer to the Social Security Administration and fill out annual reports, in some ways similar to a guardian, saying, that they have made sure that I got money coming in, that my rent was paid, that all of my sort of needs were taken care of. So it's something that can come into play. You don't have to go to court to get it. For right or wrong, the Social Security Administration just determines on their own if the person has capacity or understanding of their finances and will decide to appoint a rep payee or not. It cannot be the greatest thing. It can be very helpful for people who need it, but it also can be very restrictive, as we say here, because once you have a representative payee, you don't have control of your SSI and SSDI benefits. It has to go to your benefit, but it goes to your representative payee, who then sort of gives you the money or pays your bills themselves, and you don't have control over how that is spent. Next slide. So what do you do if you have somebody, or you are somebody who lacks capacity, meaning you don't understand, you don't have the ability to make your own decisions? Under DC law, there are some options that are less than guardianship. The first one being in the educational arena. OSSI, again, the Office of the State Superintendent of Education in DC, has created a law and regulations that has created a procedure where you could appoint, where it can be appointed an adult to help someone who's more than 18 who has educational needs. If that person, two medical professionals say that person does not have the ability to make their own decisions, educational decisions, and we've attached the form here. So what that means, if you have someone who's 18, they're still in school, they do not have the ability to make decisions in the educational arena, two medical professions can fill out a form and say, yes, this person does not have the ability to make their own decisions. And then it can be, they can appoint a person, it's often a parent, who then is responsible for making this educational decisions for the person. So it's something to avoid guardianship when the person right now just needs educational decisions. And it doesn't stay in play for that long. It ends when the person leaves school or they're no longer eligible for special education, then it ends. So it's only for a specific period of time for a specific purpose. Next slide, please. Similarly, we have something called substitute healthcare decision makers that was created in the DC law many years ago. And this is in play for people, for an adult, not for children, who do not have a power of attorney, meaning they don't have the ability to execute one. They can't sign one because they wouldn't understand one. And there are two healthcare professionals who have certified that the person lacks the ability to make decisions. And for this, the healthcare professionals, one has to be a doctor and one has to be either a psychologist or a psychiatrist. And they have to say that the person is unable to make these healthcare decisions. And then once that happens, what the law does, it says, okay, so Sandy has been, two doctors have certified that Sandy cannot make her own healthcare decisions. Then it lists an order of priority of individuals who can provide healthcare decision-making assistance to me. So, and the first one, for example, is a legal guardian, a power of attorney, but then it's people like an adult child, a spouse, a parent, a friend, and it goes down the list in order of priority, but these people can make only healthcare decisions on behalf of someone who lacks the ability to make the decision. And that can be a healthcare decision based on medication. It can be life-saving treatment that's provided. It could be consenting to whether or not I want to have cancer treatment, or I should have a colonoscopy, a variety of different healthcare decisions. It does say that you have to have, when the person, the substitute healthcare decision maker, so the family member or the friend is making a decision, there does need to be a witness present when they're making the decision. And it does limit, there are certain procedures in medical decisions that the person can't consent to, things like sterilization, abortion, and things like consenting to aversive stimuli. Like the substitute healthcare decision maker couldn't consent for me to go through shocks to address behavior, for example. They're not allowed to consent to that, but they can consent to other medical procedures, and DDA certainly uses this a lot. They've created a form. You don't need a form, but they've created a form that exists in the DDA file that lists who is the substitute healthcare decision maker if someone is using this law to help them provide decision-making support. So it can be a great option. It avoids guardianship if the person really, their focus is on healthcare decisions. It doesn't help you with any other decisions such as financial or housing or any other decisions other than healthcare. I'm going to turn it back over to Sean.
Thanks, Sandy. So Sandy has given a good overview of the most used alternatives to guardianship in the district. And we wanted to make sure before moving on to the next topic to share an important resource that exists here in DC. And that's this decision-making guide called When Adults Need Help Making Decisions and Managing Daily Affairs. We've given you a link to it here on this slide. It was authored by the Council for Court Excellence, but both my organization, Quality Trust, and Sandy's organization, Disability Rights DC, had an opportunity to review and provide input into the guide. It is lengthy because it is very comprehensive. So if you want any more information, we encourage you to download and take a look at this guide. But as Sandy said earlier, you're also welcome to give either of our organizations a call if you have more questions about the different options in DC and what one makes the most sense for your family and your individual situation. Next slide. So I thought it was important to sort of put this question out there, which is, okay, but what does this have to do with future planning? And that's because everyone's ability to make decisions changes across their lifetime. And that includes the ability of people with intellectual and developmental disabilities and the people who are taking care of them. Young people can learn to make better decisions as they grow up, and they might not need a power of attorney or, well, I'm not going to use that one, but they might not need a guardianship if they have one because they've practiced making small decisions and then bigger ones and gotten better at recognizing sort of the good and bad consequences of their choices. And so their decision making improves and they no longer need a restrictive level of support. On the other hand, as people get older, they might lose some of their abilities to make decisions as well as they used to. And it might be harder for people to make decisions on their own or at all. There's some research out there recently that people with intellectual and developmental disabilities are at a particular risk for developing dementia and Alzheimer's as they get older. So while it's important that caregivers think about their own capacity and the support they're currently providing and what they need to put in place for themselves, it's also important that caregivers think about their loved one with a disability and what happens if their capacity changes. Planning for these changes is so critical so that decisions can be made even if a crisis comes up in the family's life, the person's life, or in the supports they're receiving. Next slide. So this is true for everyone, people with disabilities and people without disabilities, that unexpected things can happen at any time that might affect your ability to make your own decisions. And if you don't have plans in place, like the power of attorney that Sandy was describing for herself, options other than guardianship can become very limited. So it's really important to take steps, frankly, right now, if you haven't already, well before a crisis happens, when things are calm, to make sure that the choices that you want made for yourself or that your loved one with a disability wants made for themselves are respected. You should think about the decisions that might be made in the future. And if you can't make your own decisions, who you would want to make them for you if you can't make them for yourself. And then you should write those wishes down and execute legal documents that protect those wishes, including many of the things that Sandy discussed, like powers of attorney and advanced healthcare directives. We've also shared a link on this slide called a letter of intent, which is a really comprehensive document from the ARC Center for Future Planning that talks about sort of people's everyday needs, contact information, medications they take, who their doctors are, their day-to-day schedule, and the things that are really important for them to maintain consistency in a crisis. It's a really valuable tool that I recommend everyone take a look at. Once you've written down those wishes, though, it's very important that you make sure the people who are supporting you, like your friends and your family members, staff people who are supporting individuals with disabilities, doctors and any others that are, service coordinators or other case managers, make sure they know what the wishes are and that they have copies of the legal documents. And then finally, it's really important that you review these plans because things change, and they can change at any point where the needs for, last year I wasn't able to make decisions. So I had a power of attorney, but now I am able to make decisions. So I want to change my power of attorney or revoke it. It's really important to review whatever current legal arrangements you have on a regular basis. We recommend at least once a year so that you make sure you're updating them to reflect the current situation for you or your family member. Next slide. Another situation to think about for individuals who have a guardian is what's going to happen with decision-making if something happens to the guardian. While guardians are authorized to make, they're authorized by a court to make decisions for the person, it is established best practice for the guardians to support their the person under guardianship to make their own decisions as much as possible and become as independent as they can. And so if there comes a time when the person has improved their ability to make their own decisions, they should have their rights restored. But plans need to be thought about for any time that a guardian isn't able to make a decision for any reason, even if it's a really short-term temporary reason. Make sure that there's a plan in place. So the recommendation is to, for the person under guardianship and the legal guardian to sit down with sort of the support network and identify 2 or 3 people who could make decisions in the guardian's place if they weren't available. They should think about who they trust, what decisions might need to be made right away, immediately in a crisis, like a life-saving healthcare procedure, versus a decision that could wait if the guardian is only temporarily unavailable, like maybe they're out of the country and very hard to reach for a week or 2. And after that discussion, the legal guardian needs to share decisions that have been made about those alternate decision makers with people who need to know who those are. So that might include doctors, service coordinators, people providing services. But for someone with a court-appointed guardian, it also includes the court. The court can include an alternate or not an alternate, but a successor guardian in the guardianship paperwork. So if you are someone who is currently a legal guardian and the guardianship paperwork doesn't already identify a successor guardian, we strongly encourage you to start thinking about who that could be, who those trusted individuals are, and have that information in the court documents. Though again, if then you change your mind and you don't want the person you've chosen or the person you've chosen themselves has passed away, you'll have to go back to the court and have those documents updated, which is why, again, it's really important that you're regular reviewing regularly reviewing whatever the current legal decision-making arrangements are and updating them to reflect whatever the current situation is. So that's all Sandy and I have formally to present, and we're happy to answer any questions that Susan or Allison, if you guys have thought any, or certainly that any are hadn't seen any in the chat, but if anybody wants to add any in the chat, please do so.
I do not see anything in the chat right now, but as people are maybe getting their thoughts together, and I believe you touched on this, but I just wanted to ask one more time to make it clear. If I wanted a, if I wanted someone to make financial decisions or help me, assist me in financial decisions or healthcare decisions, does that have to be the same person, or can those be different people?
Absolutely, it can be different people. When the court's not involved and the person is choosing who they want to make decisions for them, they could say, for example, when it comes to going to the doctor, I really feel safe when my mom is with me because I'm a girl and she's a girl and she's gone through the things that I've gone through. So I want my mom to be the person who supports me or who makes decisions for me when I can't make them for myself when I go to the doctor. But my dad is a banker. And so he really knows and gets money. And I know he pays my mom and dad's bills. So I really want him to be responsible for my money. So I want him to support me in making my own financial decisions and handling my money. Or, I want my dad to make those decisions for me if I can't make them for myself. So absolutely, a person can identify different people to make different decisions depending on who they trust and who they think can best support them.
This is Allison with the DD Council. Sandy and Sean, I want to echo thanks to you and ask a question that's more of a discussion and maybe something on people's minds. How do you manage some of the emotional aspects of these conversations and the challenge of having these conversations with family members that don't want to talk about it? Do you have tips about how to approach it when it's taboo to talk about, or, we don't want to think about our death, and we don't want to think about, losing capacity to make decisions, and it's uncomfortable. So what tips or recommendations do you have about how to approach that with families?
Yeah, I mean, I can tell you just personally, I've recently had to have these conversations with my parents. And so using a lot of the same sort of techniques that I use with my parents, who are fully capable of making their own decisions right now, but may not be tomorrow or in 5 years or in 10 years as they age. I think, what we do in my office is we want to talk to the person, with a disability or anybody and say, all of us are going to need decision-making support at some point in their life. And it's important to make decisions now when you have full capacity and you're able to make those decisions about what you want and who you want to help you make decisions. For example, with my parents, they have both very different opinions about the life-saving techniques that should be used. My mom basically is like, let me go. And my dad is like, any invention that could keep me alive for another minute, that's what I want, right? But unless you put that in writing and you assign someone who you trust, who's going to follow your wishes, you don't know if that's going to happen. So really talking to people and saying, this is something we all go through. And you want to be able to make the decisions. You want to have control about what is important to you and who helps you make those decisions. And so now is the time to do that rather than when it's in a crisis. You don't want to deal with that in a crisis. If you're in the middle of a healthcare problem and you're dealing with everything that comes with that, then trying to decide like, oh my gosh, who's my decision maker if I come out of surgery and I'm a little, I don't have capacity for a while. Who do I want to do that? You want to make that decision when you're calm, things are well. And you really, you know who in your life, there may be people who you're closest to, but you don't think that person will make the decision you want. You want to be able to decide what's important to you and who you believe will follow that now. And that's what we tell people. And that's, because that's what we all do. And I think if you describe it to someone as, this is something we all go through, it's important. This is not something I'm discussing with you because you have a disability. This is important for all of us. That's how we sort of approach it, both in my personal life and professionally in the office.
And I want to thank Robin Shafford. She added a link in the chat to a resource that the Eric Center for Future Planning created called, it's a tip sheet on getting the conversation started. Because Allison, as you pointed out, like this is one of the biggest barriers to people. And we talked about this, Robin talked about it at her presentation at the provider or the DDS community organization and provider fair last month. And we talked about it a little bit in the overview in the first session of this series. One of the biggest barriers to people starting future plans, and I have to admit, I'm someone who talks constantly about future planning, and I do not have any of these documents in place myself. So, one of Robin and I's colleagues at the ARC, who is a sibling of a woman with intellectual and developmental disabilities with a mother who is in her late 70s and having some health issues, she used to joke, my job is literally to tell people to future plan, but we don't have one because my mom won't talk about it. It is hard, and certainly check out the tip sheet, but in addition, I would just add that gently and often, not so much so that you're like, every single time the family gets together, this topic comes up, because then you start to alienate people and they don't want to hear it and they'll shut down. But every once in a while, when you're watching a movie and something happens, or when the moment seems right, if everybody seems open, maybe not at Thanksgiving dinner when everybody's enjoying their meal, but when the opportunity arises, just continue asking, continue raising, because it's so important that it happens, even though it is uncomfortable and hard.
Right. And I know this isn't the financial part, and I don't know what was discussed at that session, but it's also important, yes, to make financial plans, especially if you have somebody, a loved one who's going to inherit money and they receive SSI or Medicaid, because we see this a lot where, someone gets left a house, maybe it's worth $300,000, which sounds great until they lose their benefits and their Medicaid. But had it been put in a trust, that wouldn't have happened. So yeah, really being able to, because that can happen to any of us. So yes, I think Robin put in the chat early. Yes, the earlier the better that you can start planning, because you never know what's going to happen. And you want to make sure that your loved ones are taken care of and they have the life that you want them to have and they want to have.
So that
Sandy,
really,
I don't know if you actually read the Q&A, but that was literally the first question in the Q&A. So way to anticipate that question.
Wow.
let me read
did
it out loud.
Go ahead.
This good foresight there. So somebody asked, I want to make my loved one who has a disability my beneficiary. Should I put this policy in a trust for them so it doesn't affect their SSI or Medicaid?
Yeah,
So,
I mean, in that case, you want to go to a specialized attorney. Well, you have options. In DC, you could talk to someone at the Shared Horizons, the Vinner Trust, which is a pooled special needs trust for people with disabilities, and there are ways to set up sort of leaving to set up an inheritance that goes to the trust. You really want to, this is one of those things where you don't want to go to Staples and get a book and figure out how to do it. I wouldn't do that either. You want to go to an estate attorney who specializes, or at least knows a lot about special needs trusts, because there's language that it's not a regular trust. If you leave money or inheritance for someone who doesn't have a disability, it may be called a trust. But that's different than a special needs trust. It has to have specific language in it to make it a valid trust. And to make it a valid trust is important, because that what makes it stop and not affect the person's SSI benefits or their Medicaid benefits, or it can be other things like public housing benefits and things like that. So you really want to, sooner rather than later, even if you have, you're feeling great, you're 45 years old, to just set that up. If you don't have money when you die, then nothing happens, but that you've set up a trust so that when the person with a disability inherits the money, it goes, from inheritance right into the trust and never goes to the person's bank account for Medicaid or Social Security to see it and then cut their benefits off. Because maybe if you inherit $3 million, you don't need SSI, but no matter how much you inherit, you always want to keep, in my opinion, your Medicaid. Because as we all know, the medical costs are extraordinary, and $1 million could go like that. And so it's really important if you are someone who's going to leave an inheritance for your loved ones, that you talk to a specialized attorney who focuses on special needs trusts. That's not us.
Right. Exactly. Neither Quality Trust nor Disability Rights DC. While Quality Trust is in our name, it is not that kind of trust. It's very important to know we are not the right resources for that. I actually put a link in the chat to the Special Needs Alliance, which is a national organization. Well, it's a sort of collaborative group that identifies special needs planning attorneys in each state. And I will add, we have the luxury in this area of the attorneys who practice in both Maryland and Virginia are also often licensed to practice in the District of Columbia too. So if you're a DC resident, you're really probably not limited to the people listed for DC. You're probably able to reach out to the attorneys in Maryland and Virginia as well. And we did talk about this issue of saving for the future in the last session, which Allison posted the link to in the chat. And it's a great thing to be thinking about. It's really important to plan for money in the future, both for people with and without disabilities, but for people with disabilities, it's really critical to be thinking about how money that they might receive in the future could affect any of the supports that they're going to need. And the fact is that most of the long-term supports that people get to work or to live or to have their medical needs taken care of are often only covered by Medicaid. So it's really important to know that, to help the people know that and apply for it who may not be getting it currently, and then to protect their eligibility by making sure that there are things in place so that you can save, because it is important to make sure that people have what they need to have a quality of life. And there's often money attached to those fun things that we all want to do to have a robust, meaningful life. But we want to also protect benefits, and that means saving things. And we talked about both ABLE accounts and special needs trusts, and it really depends on how much you're talking about. Anything over $15,000, $16,000, $17,000 at one time, you're probably going to want to put in a trust. And as Sandy was explaining, there are a lot of rules about how that trust is set up and what it looks like so that it's done right. And the Special Needs Alliance has attorneys who have a lot of experience doing that. So I encourage you to check that link out and reach out and speak to one of them.
Thank you for that. So another question that you kind of touched on, but I don't know if there's anything additional about leaving a home to a person. You would put your home in the special needs trust. Is that what you were saying?
I mean, this is why you need to talk to an estate planning attorney.
Yeah,
and
I don't
not
know.
me or Sandy, because there are some exceptions to the asset rule for homes that you live in as your primary residence. But please don't take anything that I would say on this topic to heart. You need to talk to an attorney who knows what the heck they're talking about, and that's not me.
Yeah, same.
I think the answer is it's a good idea to leave the home to a trust so that it frankly can't be sold out from underneath the person with the disability, but an estate planning attorney should have that conversation with you and your family to understand your personal situation and what is the right thing for you.
Thank you. All right, another question we have. Also, I want to share a comment from Tamara that said, thank you all for answering my questions and sharing this invaluable information with us all. This is very needed. DCPS and OSSI need you all to regularly speak with parents and caregivers of children of all ages, so we'll be better informed and not just in the education aspect.
Absolutely. Sandy and I and the people that work for us are happy to do so. Just let us know when you're interested and where we should be.
And then another question we have, can you speak to the difference, pros and cons between a trust and a transfer on death deed, specifically in terms of real estate?
I mean, I'll add again that an estate planning attorney is really the right people, but my understanding of a transfer on death deed is that it goes directly to the person with the disability. And so that means it becomes an asset directly of them, as opposed to a transfer to a trust, where it becomes an asset of the trust and is used for the benefit of the person. So you really need to talk to someone about the specific situation and what makes sense. But if someone's on public benefits and the house is counted as an asset, then you would probably want that in a trust and not directly belong to them.
Right. I mean, I think this is getting more complicated and more beyond Sean and I's expertise. We focus on sort of the disability law and refer out the real estate questions to someone else. Yeah, and I know that for Medicaid purposes, like they do not consider like a primary home as long as it's not an extravagant home as an asset. But that's but I would not want to advise someone specifically. I would recommend that you speak to an estate attorney because that's outside. We know what we know and what we don't know, and this is something, at least it sounds like Sean and I both know.
I think that is a quality of a good person, when you can admit what you don't know and make sure people get to the right place. So I appreciate that.
We look for supporters, right? This is an example of, I don't know, so I'm going to look someone to support me who can advise me on real estate.
Exactly. I don't know if this is a question on anyone else's mind, but do any estate planning attorneys help you for free?
So the elder, oh gosh, Sandy, what's the
Legal counsel for the elderly, AARP.
Thank you.
We
So
share
the
brain.
AARP, thank you. The AARP Legal Counsel for the Elderly here in DC does offer some free estate planning to seniors. For trusts and a decent amount of money, even for seniors, you may find that you need to pay a small fee to an estate planning attorney. But if you're a person who is low income, and I think they're over the age of 60, does that sound right, Sandy?
That's right.
I would at least start by calling the legal counsel for the elderly and seeing what they can do, and if they have referrals for what they can do.
Right. Yeah, I mean, they focus on simple wills, and I think they can do simple estate, but for someone who hasn't involved, is going to cost, there is going to be a charge for an attorney for that.
Thank you. I know we have some groups that are watching. I wanted to give a minute to see if anybody at the Asian Pacific Islander Senior Center or Vida Senior Center has any questions. It might take an extra second to put those in the chat. But I just wanted to say hello to all of you watching in a group, and thank you for being here. We have one more question in our Q&A section. Can you expand a bit on what happens if you do nothing for financial estate planning and you have assets that may be inherited by a person with a disability?
A mess. I mean, I'm going to be honest, we see that. I'm sure the quality trust sees that. I had a recent case where a family member died. They were older. I don't want to say they knew they were going to die, but they knew they weren't going to live forever. And they were very elderly and had a reverse mortgage on their home. And they left and they thought, oh, we'll just leave the house to the person with the disability and we'll leave them some cash. It ended up being a nightmare because the reverse mortgage was going to take the house. But even if they didn't have that, it was only like $80,000 that he was left, which sounds like a lot, but that made him lose his Medicaid. his Social Security. And so we were scrambling, trying to get, I was counseling the family, go talk to the Special Needs Trust in DC to resolve that. So he keeps his benefits. Let's arrange for services. He was not hooked up with DDA at the time. So they hadn't planned for services at all. He needed services. He could not live independently. He could live with supports in the community. And so it was a lot of stress on the family, a lot more stress on the individual. It got resolved because, lots of people came together, but it's not immediate. And so it was bad. We were able to make sure he did not lose his benefits. But it's only because another family member reacted quickly and sort of had reached out to us. And I told them about ABLE and the Vendor Trust and things like that, that we were able to set up things quickly. It really, we've had other people where, yes, that somebody dies and they're left with no services and, a small amount of money that, just cancels all that they've lost. Now, if you inherit a big money and you lose your Medicaid, now you've just lost your staffing. For people who get personal care aids, we've had people lose their personal care aids, and then been forced to go into nursing homes while it drains their assets. And so I don't want to scare people, but in some ways I want to scare people because it's bad. And so, all of this could have been prepared for if like that family had applied for DDA services, even if he didn't go into any residential services, if they had him sort of on the rolls and they had, gone to an estate planner and planned that money or started putting money in an ABLE account, then he would have some spending money. It would have, he's okay now, but it was very scary for a while. And again, very well-meaning, loving parents, but just they were not informed about all the things that could happen. They just thought like he'd get this money and he'd keep all his benefits. And of course that does not happen. And so, yeah, I mean, it can be a real disaster. I'm sure the Quality Trust sees similar situations.
Yeah, I would add that, it doesn't take much to create a problem. And so there are people who think, well, I don't really have anything. I'm on public benefits. My child's on public benefits. And so this doesn't really apply to me. Not really need to think about it. And I guess, we meant to say this at the end of the financial planning session. And I don't remember, Susan, whether we ran out of time, but it's really important for people to at least know what the alternative options for saving are, even if you think it doesn't apply to you. Because, for example, Sandy and I have represented many clients over the years who had something bad happen to them and they sued and got some money. Nobody was expecting that to happen. And yay, this right was wronged with this financial compensation. Except the financial compensation can screw up your benefits if you don't deal with it properly. And so knowing that anything over $2,000, anything, income from a job, a $10,000 life insurance policy, the family member has a car, like nobody, they're in public housing, SNAP benefits, but they have their own car and that sells for $2,100. There you go. You're over the asset limit. So it's really important to just know $2,000 for Social Security, $4,000 for Medicaid. Anything over that jeopardizes benefits. So know about these other options and use them and plan for them and have them in place.
And also, if you don't plan for someone to maybe assist it with decision-making, we have seen situations where a parent dies and the parent had always had the person living in the community and then they die. And then a family member comes in and says, I'm just going to put him in a nursing home. And that's the one that steps up. If, maybe there had been arrangements for who was going to help the person make decisions when mom and dad passed, they would have been able to keep living in the community. And so you just want to make sure you prepare, because it's not like that it was an evil family member, but they thought being in a nursing home was the best solution, but that's not what the person wanted. And it's not what the parents wanted. And so you really want to make sure, like all of us, that we plan for who we want to help us make decisions and what those decisions are, what we value. Our powers of attorneys all say, we add a lot of language to ours that say like where I want to live, I want to live, we rank them. I want to live in my own home. I want to live in supported living. That's something the DDA provides. I want to live in a nursing home, whatever it is. We have laid this out. So it's clear, this is what is important to me. If someone is making decisions, that it's very clear.
Thank you. We have another comment in the chat that I think might be perfect for closing us out. Thank you, Tamara. Tamara says, we appreciate this talk. We thank you for answering what you can and referring us to those who can answer other questions. Talks like these make you think about not just your loved one's life and care, but your own. A hard conversation, but very much needed, especially in my community of African Americans. Thank you so much for sharing that. I think we all agree, and I want to thank Sandy and Sean for your presentation, and thanks Susan for your presentation, and all of the partners in the Bridging Aging and Disability Networks and Racial Equity Community of Practice. This was a team effort. Sean and Susan took the lead on planning this series, and so I want to give them a special thank you for taking the lead on this. And thanks to everybody who came out to participate and anybody who might be watching this after the fact. We'll post all these resources on the website, and really appreciate everybody and hope that you have a great day and keep thinking about these important issues. Thanks so much.
Thanks,
Thank you,
everyone.
everyone.